It's certainly a very warm afternoon in this very rainy East Africa. My name is Gabriel Achaye, and I am speaking to you live from the East Africa Law Society House at PPF Njiro, Arusha. Always feel free to pass by when you're in the vicinity of Arusha. This afternoon, ladies and gentlemen, we are profoundly honored to host this very exciting session that comprises of a very distinguished panel of titans who have not only excelled in legal practice, but have led a path for many of us young lawyers to follow through. This session is titled Through the Eyes of Legal Titans, Navigating the Evolution of Legal Practice, and we'll be looking at insights, challenges, and strategies for success. Now, our session is moderated by two very eminent legal practitioners. One, my teacher, Miss Linda Alinda Ikanza, who is a partner at Amber Solicitors and Advocates, and Mr. Robert Okot, who will be her co-moderator. Ms. Ikanza and Mr. Okot, we are profoundly honored and exceedingly humbled to have you at this session, and we look forward to your wonderful insights as we learn from our titans. So I'll hand over to you for the next 2 hours, and we hope to learn and push on with it. Thank you.
Thank you very much, Gabriel, and good afternoon to all our wonderful, wonderful attendees. Thank you for taking the time to join this very important conversation. I've just been reflecting about who a titan is. And a titan is a person or thing of very great strength, intellect, or importance. And as we start to introduce to you who the people we are privileged to sit at the feet of this afternoon, you will really see that they are titans. The conversation this afternoon is a reflection on how important the period or the transition that the legal profession is going through is, because we stand at a pivotal juncture. You all will agree with me that legal practice, as we looked up to it when we joined, as we admired it from afar as little or young, very young people, as we joined it with such great zest and expectation, is changing much faster than we can cope. And with the advent of the digitalization or artificial intelligence and the whole impact of the digital market on our courts and practice, the way legal services are delivered is changing. And yet our currency is still trust. Our fidelity to the law, to the court, and to the client still remains. So despite the changes in the tenets of our profession, the integrity, the diligence, and the justice that the public still expects from us has not changed. It remains steadfast. And I want to believe that the kind of change we are seeing must be the kind of change these titans saw when they were joining this profession. So to this afternoon, as we listen to them, as we drink from their wells of wisdom, they will offer us the clarity and the shared experiences that can help us navigate. Because what is true about life is that the more things change, the more things remain the same. Sometimes when I am overwhelmed about what I think my daughters, how I think my daughters perceive the world, I remember that my parents probably had the same overwhelming experience when they were raising me. So there is so much that we can learn this afternoon from our titans. And I want to turn it over to my co-moderator, Mr. Okot Robert, to introduce each one of them. And then we will listen to them and each of the presentations and wonderful meals they prepared for us. And then after that, we will open it up for for engagement, for questions, for a Q&A session. So in order of how they will speak to us this afternoon, we'll hear first from Mr. Alex Rezida, and that will be followed by Her Excellence Ambassador Mwanaidi Maja. And I think that I have murdered that despite all the practice that she bestowed on me. And then we will hear from Honorable Professor Haruki. I won't try. I give up. My Western tongue is shaking at the sheer courage required to pronounce these Kenyan names. But we are going to hear a detailed introduction of who each of these titans is from Mr. Port, as each one of them takes the floor. So over to you, Robert.
Thank you very much, Council Alinda, for that, for those kind words, but also to welcome our panelists to this very important discussion. To start with Council Alex Rezida, I know I haven't had the opportunity to receive his more detailed bio, but just briefly, Council Alex Rezida is a partner at Nangwala Rezida & Company Advocates. He's been practicing for quite a long time, and we are hopeful that his experience will be very instrumental in going forward with this conversation. You're welcome, Council Alex Rezida.
Thank you very much, Robert. And good afternoon, fellow panelists, and good afternoon, all participants present and those that we hope to have online going forward. I'll be talking this afternoon about really sharing experiences and looking at certain changes. The first bit being reflections on legal practice in the pre-digital era and trying to see what the digital era has, in broad terms, visited on us. I'll also be talking about a transition from courtroom-centric work to the diverse services that a legal practitioner does offer, be it transactional, legal advisory, and so on. I also talk about the evolution of legal education with emphasis on practical training versus theoretical focus that most of us were subjected to during our training as lawyers. And so going straight to the first part, if you could have the first slide on reflections on legal practice in the pre-digital era. The broad theme for the topic for this afternoon for all presenters is From Quill to Cloud, the historical arc of legal practice. In there, I just captured a reflection in broad terms of what the law is, just to remind ourselves that it's more than a robotic application of laws. Law is used as a social device to reflect society's changing attitudes and practices. Next, please. Now, the presentation is divided between two eras, the pre-digital era and the digital age, and looking at a possible impact of this shift. Now, if we sum it up, we are talking about looking at what I'd say is the analog era, and the digital era in terms of legal practice. Analog refers to a period before computers as we know them today. That's a time when widespread use of information communication was not as we know it today. The digital age has revolutionized that. And beginning the 20th century, the shift from analog is marked by how information and media is created, processed, consumed. The internet revolutionized access to information globally, including on portable devices that make it more accessible to all users that have those gadgets. Simply accelerated what was already a creeping practice on us. The COVID era is what introduced us broadly to virtual and flexible work. And that has kind of remained a feature in many industries, not so much in the East African legal space, but also significant in terms of the flexibility with which legal practitioners do their work. So remote working is indeed a feature of the digital era that was inconceivable in the analog time, in the pre-digital era. Now, currently, the vast talk, the biggest experience we are going through is AI. AI, as we know, started with the extractive method. That's where AI was extracting information, data from materials that were fed into a system. Then to move on to generative AI, where, like the word suggests, AI generates ideas, generates documents, generates whatever is required by a user. And now we have the agentic AI. Agentic AI is where you say, Robert, you have an AI agent for Robert. And that AI agent assists you in your professional decision-making. And so that AI is going to understand you, Robert, the user, you who subscribed, they give you an AI agent, is going to understand you, understand what you do, understand if you're a criminal practitioner and you're in East Africa, help you in understanding what the definition of murder is, what the latest decisions are, and help you generate work in a professional way, help you in making decisions of what you need to do. And indeed, what sounded like science fiction not too long ago is now a reality. And that's why today lawyers are debating whether they are an endangered species or not. And that's a reflection, a key reflection on the fast pace of what we are seeing in the world today. And one major reflection, if you look at pre-digital age and digital age, is a shift from reaction, you react to it, to being forced, literally forced to recalibrate yourself, recalibration of legal practice to suit the pre-digital era, the digital era that we are in today. So key things that we can reflect on. Pre-digital era, reliance on paper documents, paper-based practices, contracts, pleadings, correspondences. I'll give one example, and this is a personal experience. Imagine someone comes and wants to incorporate a company, and so you are going to draw the memorandum and articles of association. And of course, those days, they were a bit longer than what the current Companies Act tells us to do. So you are going to have these memo ads drawn, you write them out, have them typed, but you need 3 originals. So how do you do the originals? Because the typing at that time, especially the typewriters, were the type that used carbon copies, could only give you 1 original at a time. Now, the time you spend in doing all that, the time you spend retrieving paper files, inefficiencies in managing information. Imagine you are looking for authorities, you are looking for case materials, you're looking for textbook articles, you're looking for Professor Kariuki's article, you don't even know where to get it from. You are shuffling through many papers. What the digital era has done is to introduce management systems for quick access and secure storage. Next. Now, in terms of rigorous research, comes the same thing. The pre-digital era conducted in printed materials requiring physical visits to libraries, whether you have library in chambers, which most of us still do, or if not all of us, or you go to court or to another library. But that physical visit was a must. There was no shortcut to it. You'd spend a lot of time trying to look for subject matter, trying to look for statutes, trying to understand your subject matter analysis. You dig deep into physical texts, physical documents. The digital era has revolutionized all that. So time spent, effort, incidentally, what's not on the slides, and the stress that comes with failing to find an authority you know exists, but you can't get your hands on it. In the pre-digital era, that was a frustration. So you have stress factors that come in because of the inefficiencies. All those are taken away by the digital era. The digital era gives you database for quick references, more accurate access. It has tools for rigorous research, gives platforms, making it faster and more efficient to get to the subject matter of what you're looking for, to what you need. And so the vast amount of very, very much enhanced. We have examples in the Ugandan case, Uganda Legal Information Institute, which is the creation of the judiciary. And it's really, it's like a go-to. It's like a must-have. It just has all decisions, latest decisions, updated, very comfortable to use, accessible wherever you are as long as you have the right gadgets. Then you have legal technology innovations. We talked about AI. AI helps in reviewing contracts, looking at documents, looking at pleadings. We've got to take care in using AI, of course, and there is always caution about accuracy, authenticity, and so on. We have Sharia. Sharia is an app by a Kenyan company, and it's just an app. But in that app, it has the laws of Uganda, the laws of Kenya, the laws of Rwanda, the laws of Tanzania on a click. On a click, you have the Companies Act, you have the Land Act, you have the Civil Procedure Rules, you have whatever you need. You have LexisNexis, wide range of applications there. You need to know the size of your farm, you need to know your budget, you need to know what you want. I've indicated there indications of ranges, not cheap in our economies, in our settings, not easily affordable. It's not that have to pay $20 per month for entry-level usage, or $33 per month for the for the premium Copilot packages. You have Microsoft there. We have Westlaw as a source. Now, all this, of course, and this is the other aspect of the digital era, come with certain requirements. You need stable and reliable internet. You have to have an IT-enabled office. You need to have computers. You need to have smartphones. So the digital era also comes with, it's not cost neutral. It's not cost neutral at all. It comes with budgetary implications for the legal practitioner. And one aspect that you have to always be mindful about is being constantly updated. In fact, you can change that updated as well to apps. Are you constantly aware of the apps that are there? This slide just shows it's a summary picked from LexisNexis and shows you where we are headed and what they're doing. I just read through it quickly. We are proud to once again begin on the leading edge of legal tech innovation. Agentic AI, which guides users to perform tasks aligned with their workflow through customs AI models known as agents. We've gone through this. I talked about the agents. We go to the next slide. AI in LexisNexis is a big thing now, like other platforms that we lawyers are using today. Next slide, please. Communication. Now, the digital era was typically through meetings, would be through physical meetings, landline calls, letters, fax, and so on. It's such a change when you come to the digital era with instant messaging, with WhatsApp, with email, efficient communication. And incidentally, in Uganda, we have court decisions that now allow WhatsApp service of court process, for instance, or formation of contracts on WhatsApp. And that's very uplifting in terms of the development of our jurisprudence, showing a shift from the digital era to a shift from the pre-digital era to the digital era. Next slide, please. Case management. Case management, again, pre-digital era, paper-based, walk there, have a clerk to go and do assessments, go and pay fees, bring back receipts, go to the registry, do all that, work with receipts. Tracking was a challenge. Navigation was very, 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 very cumbersome, navigating court systems to understand where cases are, what's going on. Very, very difficult. The filing was purely in person, slower, time-consuming, and subject to easier manipulation. The digital age has brought in software that enhances organization and brings in efficiency in case management. And by case management, we're talking even about internally. How do you in chambers keep track of the cases you're handling if you are talking about court work? How do you keep track of transaction work you are doing in chambers? The digital aspects make a hell of a difference, reducing costs and increasing efficiencies. Billing practices, manual time in tracking and paper invoices, resulting in administrative burdens, easy to miss out a few things because of poor filing or loss of documents on file. The digital era brings in automated and streamlined processes that keep your tracking in real time. And so, because your tracking happens in real time on an ongoing basis, at the end of an assignment, at the end of a case, at the end of a transaction, on a click, you are able to pick all the aspects of what has transpired that informs billing. Pre-digital era depended in marketing and client acquisition, word of mouth referrals. We still do that, yes. The print ads in the traditional sense, with limitation, the ads in a sense of the limits in which advertisement is permissible in jurisdictions for legal practice. So this limited visibility and there was very little access to online platforms that existed at the different forms over time. Today, it's so easy. The translation of websites, social media, online presence, the enhanced visibility. You have X-Space. Of course, each time we talk about advertisements, you have to remember they are not cost neutral as a drawback. Next, please. Court procedures, navigating paper-based court systems, physical filings, we've talked about that. Now we have electronic filing systems that enable submissions, enable pleadings, enable updates showing you which judicial officer your matter has been allocated to, showing you the status of the case. And in Uganda, we have electronic case management information system where we submit all documents digitally rather than in person. And again, we have it is on ECMIS, and you're on ECMIS, that's proper service, you are bound. This has reduced paperwork. We still have paperwork, yes, but this has reduced paperwork tremendously. There is nothing as joyful as seeing a judge come in court with only a laptop and no paperwork. So you stand, you read your evidence, you make your submissions. Now, practice specialization. In the pre-digital era, lawyers handled diverse cases, limited specialization resources. So specialization was less pronounced compared to today. There are fewer resources for niche areas of law, and many lawyers handling diverse types of cases and transactions had it difficult to really identify themselves. You'd find a letterhead claiming that this law firm does everything under the clouds. And you're wondering how. But today, with great access to online resources, there's heightened specialization. There's a compulsion to say who you are, demonstrate what you do, and be clear on your competencies and be clear on what you don't do. Next, please. Continuing legal education, and this is also, it has an impact on specialization. Pre-digital era, we were confined to in-person seminars and workshops with limited opportunities for professional development. The challenges of staying updated with legal developments were enormous. Today, like we are doing today, this afternoon, I'm going to enjoy picking Professor Kiriuki's brains on a vast range of subjects without necessarily sitting with him physically. And I'm going to learn. This afternoon, I'm going to learn. That shows you how easy it is, how flexible it is. It has also made it easier to choose, to specialize, because the resource material for any niche area you choose is enormous today. Next. There are ethical considerations, professional guidelines. There was less reliance on the digital resources for compliance. Now, today, there is a lot of it. Emphasis on personal integrity, yes, but today, the online resources improves adherence to these ethical standards. The applications of the regulations, a bit of regulations, updating yourselves on the best practices around the globe. If you want, you can narrow them down to East Africa, get to know what is going on, and ensure that you stay in a clear lane as far as ethical considerations are concerned. Community engagements, again, clients in person compared to today's digital communication. Well, there may be a bit of disconnect from personal contact, but the thing is, we have a choice. So we do a hybrid. I don't have to meet a client all the time physically. We meet, yes, when it is a must, when it is necessary, but the rest of it will be done online, will be done virtually. So it gives that flexibility in how you engage, how you meet. When it is a must, it's physical. When it is not, you have a choice. And then the rise of virtual law firms. Next, please. So in conclusion, we've seen the efficiencies that come with it, but we have a hybrid. And this hybrid of digital, manual, is going to stay with us for some time. Yes, the digital divide is going to be wider and wider. We must also be aware that practitioners value uptake and adaptation to the digital age. But what has done in Uganda Law Society speak, digitization is banging our tables. So that is it as far as reflections on legal practice in the pre-digital era is concerned. We'll now go straight to the evolution of legal education. There will be overlaps to run through it quickly. Now, this presentation, I based it on 2 articles, which I displayed there. We'll go to the next slide, please. I simply looked at these 2 articles that really capture what it is that has gone on. So the narrative in it is, because it serves as a backbone of legal profession, it shapes individuals and helps us to navigate complex legal frameworks. Now, Uganda's legal education system is evolving to meet contemporary challenges and align with the global legal trends. These trends emphasize active learning, problem-based learning, practical skills development, technology integration. And this is what equips someone with skills to navigate a dynamic and changing landscape effectively. The key drivers for evolution in legal education globally are internationalization, transnationalization, mobility of capital. You find international law firms in our jurisdictions. We have a number of Uganda partnered with law firms here. Then globalization, EU being an example, even East African community. We now have a lot of activities going on in Arusha, but we also have statutes, we have customs union. So that globalization impacts on legal education. We are forced now to learn what happens in those spaces because of these changes. One of the world's most regulated spaces, EU. I don't know how many regulations they have. It's such a web. It's a nightmare for legal practitioners over there. We have the historical evolution from informal apprenticeship to formal schools, the first university being Brona School of Law. Then the parallel growth in the complexity of legal systems and the journey to try and be up to date, even as legal practice itself, even as the laws itself. So moving from mentorship models to structured reform education is something we've seen over the years. Next. The current pedagogical models, traditional case method emphasizing legal reasoning, lecture method, memorization. These have career-limiting limitations, such as lack of practical skills and interdisciplinary perspectives that we face today, especially in non-court work. So clinical legal education that focuses on practical application and incorporates technology is something that is evolving quickly, is something that we need to be focused on, the practical application, as opposed to memorizing legal provisions and authorities and so on. Because problem solving is a key requirement of today's legal practitioner, and to do that, to add value in transactions, is something that requires practical skills, requires appreciating interdisciplinary perspectives of legal practice. So we'll see in the next slide the technological integration and what it means in the context of skilling for today. We have the rise of virtual classrooms and online resources. We have digital tools such as online research. We have cyber security issues, digital integrity to mind even as we go on. We have e-learning platforms which offer flexible learning environments. And in doing this, we are addressing the requirements of the digital divide in legal education. There's a link there for those who are interested in going deeper into this digital literacy training, equitable access to technology, and then the universal design of learning. Again, still the integration. The key driver in this is to understand that learning presents challenges in maintaining academic standards, especially with the ease with which people can use AI, and securing student engagement in a digital landscape. Linda lectures at the Law Development Center in Uganda, and she will tell you amazing stories of the attempt during COVID to engage students to learn remotely, and how students would, log on and move away. And you call out and you reach out and there's no one. Some forget their cameras on and they show you where they are, and they're typically not with you. So those challenges do impact on standards. Move on to the next slide, please. Clinical education really is about internships. It's about bridging theory with practice, fostering critical skills, enhancing ethical reasoning through hands-on learning. And clinical legal education is so essential in developing today's competent, ethical aware legal professional. And a debate should now be going on. Are we doing enough? I look at the time students in Uganda spend on clerkship, and I think it's too short. If you look at the importance of clinical education for today's legal practitioner, we need to revisit this time that students spend in clinical education. Next slide. Ethical considerations, integrity issues, ethical conduct, again, data protection issues, academic honesty, and professional responsibilities. So ethical considerations are paramount in legal education, but even more paramount today in the digital age as far as legal education is concerned. So the educators have a lot of work in instilling moral foundations in today's youth. Diversity and globalization, yes, the importance of inclusivity and representation in legal education, understanding international and cross-cultural legal practices, adapting curricula to reflect diverse legal perspectives. Because the legal profession is increasingly globalized, the diverse legal education that is required is very, very important in understanding the broader spectrum of perspectives to ensure that all voices are represented and understood. Continuous innovation, new methodologies, focus on interdisciplinary approaches in legal education. These call for self-drive in continuous innovation. That's something that has to be inculcated in today's students. Next slide, please. So in conclusion, we see that the necessity for cooperation among educators and policymakers is very, very, very critical. We look at the education as a dynamic field requiring constant adaptation. We look at the evolution and challenges of legal education, the demand for proactive approach in ensuring that emerging lawyers are required not only with legal knowledge, but also with skills to navigate the complexities of today's legal landscape. The time allocated to me is over. And I hope that these slides will be available to those who have attended. I don't know if we have a Q&A now or later. Robert will guide us on that.
Thank you so much. Thank you so much, Mr. Resida. Thank you for taking us down that trip, down that memory lane trip. You know, it's amazing how much we take for granted as people that have come to the practice more recently. To date, I still save automatically. I don't know if any of you come from the flip-flop, the floppy disk era, where if anything happened when you had not saved, that was it. I still have the trauma of losing courseworks and research papers. And even up to now, after 4 lines, I will save, Control S, Control S. And I'm sure that is a trauma and a phobia that young lawyers after our time don't have. I have to admit that the enthusiasm with which you took us and navigated the current digital landscape is inspiring, and I bet you are ahead of so many of us who are younger than you. So it's as we turn it over to our next speaker, who Robert is going to introduce. I want to take a minute to introduce Uganda Law Society President Emeritus, Senior Counsel Andrew Kasirye, who has joined us. He's one of our panelists today. So over to you, Robert, to introduce Her Excellency Ambassador.
Thank you very much, Counsel Alinda. Ambassador Mwanaidi is a senior partner and chair at Rex Advocates, one of the top law firms in Tanzania. She has extensive commercial, corporate, and governance expertise as a practitioner and director of various public and private corporations. She currently serves as the chair of the University of Dar es Salaam Council, a government-owned university. Her Excellency was Tanzania's ambassador to the USA and High Commissioner to the UK between 2006 and 2013. She holds an LLM and LLB honors from the University of Dar es Salaam. You're welcome, Your Excellency.
Thank you, Gabriel. Do you see the screen? Is my presentation visible? If not, can Gabriel share, please? I was trying to share this. It's not coming up.
I think we can only see the cursor.
The screen, yes.
Okay, was trying to share it, but I cannot find it. I don't know what happened.
Gabriel, are you able to step in?
Huh?
Yes, Senior, we are putting it up now.
Okay.
Yeah.
I thought I was going to be able to do it by myself, so that it's easier for me to navigate. But I will ask whoever is sharing it to be there for me to navigate. Hello?
Your Excellency, it is on now. Yes, Your Excellency, it is on now.
I can't see it. I can't see it. I don't see it.
Oh, we can all see it. I don't know if the other panelists can see it.
If I don't see it, how do if I don't see it, how do I now proceed to deliver it? I have to get my people to come over.
Can we, is it possible, Your Excellency, could we try again and we see if you can now see it? Can you now see it?
Oh, no, I can't see it. So I think, oh yeah, now I see it.
All right, great.
But No, I don't see it from you. I think I see it from me.
Yeah, I think we can try and follow along. Gabriel can follow along and keep moving the slides based on which one you'll be
That's going to
speaking
very
to.
challenging. That's going to
Can
be
we?
very challenging because I have to see it as you see it so that it's easier for me.
Okay.
Can you see my
move
slide?
to?
Yeah, can you come over? Yeah, I will be trying to quickly share it because it's, I don't see what you see. Are you on? Very interesting.
We're on the, it says East Africa Law Society, law as enterprise thriving in a competitive market.
That's okay. So, and the next one is just the.
Yes, the next
the
one then is the
introduction.
context. Yes.
The context,
Yes,
which
the
is
context.
just not the slides, but it is the context of what I will be talking about. So it's just introducing the subject. And then next, I seem not to be able to share. Can you share quickly for me?
Yes, let me see.
I'm going to share. I shared this afternoon.
Yes. It's strange.
This is not it.
This is not it.
This is what I have myself here.
Sorry, man.
We can see it right now.
You see it from me now?
Yes, we can see it. He just needs to put the slide show so that it's on the whole screen.
This one here. This one here. On the next.
On the slide, there we go. We have.
Can you see it now?
Yes.
That's better. So thank you so much. This now is, the context is just the things that I'm going to talk about. It's not the slides. And introducing Rex, so you already introduced us. Introducing myself, you already introduced me. So we go direct to also what we do. We are a commercial practice, 100%. Even our litigation is all commercial. I'm supposed to be talking about, one of the things I must be talking about is about legal practice, establishing a legal practice. And I think in East Africa, it's almost all the same. It's established as a partnership. I understand, I think there are others who already can do incorporated partnerships, but not yet in Tanzania. So you exist unregulated under the law of contract because it's a contractual relationship. And in Tanzania, it is registered through the business names, the BRELA, which is the registrar for companies and business names. And I'm assuming you do the same in East Africa, especially Kenya, Uganda, and Tanzania. Not sure about the other East African countries. I'm talking about those who come from the common law practice. Then how is a law firm constituted? Even the small-sized law firms will look like what you see if you are properly organized, because if you're going to be organized as an enterprise, you must have the proper setup that allows you to have a leadership and hierarchy where you have the managing partner at the top, and then you have partners, associates, and then office manager. This is the kind of a law firm that you have maybe 3, 4 partners. That's how I think you can get organized as a business. If you organize as a business, because your law firm is a business, you must actually have a proper office where your clients can come and see that this is where our business can be safe. You must have very professional, have the integrity that is required in financial and client dealings, so that because lawyers thrive on their goodwill. You lose that and you have no business. So you should at least as partners share responsibilities in the firm of leadership, managing the firm, I mean. If you have a managing partner, then there should be maybe a finance partner, or a partner can combine managing partner and finance. And then you must have partners that do with business development and the kind, depending on how you want to be organized. You cannot have one partner monopolizing the management, then there is a source of disputes. It's from my experience, meeting regularly is very important. Formal, sometimes informal, when you have a matter and you call all partners quickly that you can meet. And today with virtual communication, you can even include those who are traveling. Important to establish policies concerning how you register matters, how you onboard clients, how you communicate with client, how you invoice, how you bill, and how you handle financials and statutory compliance and staff matters. Especially in Tanzania, there is what is called anti-money laundering requirements, compliance requirements. All these things you have to have a policy. And when you have a policy, you greatly minimize conflicts within the firm. You must develop young practitioners by training, by the way you do the work with them. And you must also have a system that monitors their performance and clear path to partnership. They will see how they are going to make it to partner, depending on the policies you have of evaluation and staff management. And also they have to see how you plan to do your succession plan, which is very, very important. And then, of course, invest in technology. Professor was just telling us, without that today, you will be in serious trouble. So how do you build a thriving practice? The issues that you need to consider if you're going to build a thriving practice. You must understand what is happening in the legal space and what to do and what you need to do. There are changes and disruptions that are happening in the legal practice space, as you will see later, and happening very fast. And this was also said by Professor. So if you have to understand those rapid changes, especially in the use of digital apps, AI, and how to adopt, how to manage risk when you adopt these digital apps, because they are not as safe as we think they are, and they are not as perfect as we think they are. And also how to protect the client's confidentiality, because we are in the open space there digitally, and you don't know exactly how the client's business is protected. Follow changes in government policies and the legal regime, because that also will impact your business, will impact your clients. Recently, for example, in Tanzania, there has been regulations, foreign exchange regulations, that prohibits transacting in foreign currency and with retrospective application, which means contracts or engagement letters that you have with clients who are residents paying you in US dollars have to be reviewed in 1 year. So you have to understand also the client's business and the changes that are happening in that particular business, because they will come to you. Clients are saying, how do I comply to the data control legislation? How do I comply to the exchange control regulations? All these things you have to understand and be able to apply, advise your client. And that's how you thrive, because the clients have confidence in you. So when you build a thriving practice, you can build it solely local. You can do regional or global alliances or mergers if you want. You may look into, because all these things, these kind of relationships and partnerships offer regional and global reach. May be or may not be. As I'm saying this with a pinch of salt, because most likely it's the global law firm that has reached in your country, not necessarily you having reached in their jurisdictions. So this is debatable. I'm throwing it there for later. I've had the experience, so I know what it means. But we don't even have regional alliances. Despite calls for cross-border practice, not even joint ventures, except in very few cases where we partner on a matter. And the competition is wide open now. It is not coming from the cross-border. It's not coming from Kenya. It's coming from all over the world, not only from law firms, but also from accounting firms. Only a handful of East African law firms have global partnerships with foreign firms, but I can say with confidence non-regionally. Some firms have more than casual acquaintances with foreign firms, but not regional law firms. Most law firms are ad hoc arrangements, have ad hoc arrangements in which they work together to carry out a particular task, as I said, partnering on a matter. I want to emphasize this because for many years in East Africa and all our East African meetings and all our national meetings, we talk about cross-border practice. That is no longer the issue, my friends. It's no longer the issue because of what I will tell you next. Whether in the competition, where is the competition coming from? It's coming from AI and global firms, both legal and non-legal. Virtual legal firms are proliferating. Professor mentioned that. People just have law firms without offices. And they are attracting the best brains because people want to work flexi times. They don't want to be seated in one office all day. There are anytime, anywhere legal services at the moment. Over the weekend, I had a matter that I was working on, and these people are working 24/7. You've got to also work with them. We have lawyers actually without borders at the moment, and they are working on transactions in our jurisdiction. So these are things that you really have to look at. And then the use of AI is becoming normal in commercial transactions. AI continue to do research, continue to advise, although of course there are limitations in the AI, especially if you're using for transactions and legal research, you have to be careful. We saw in South Africa where lawyers were sanctioned by citing a case picked, which is a false authority picked by AI. So you have to be very careful. There's online branding, which is common now. When we started practice, I was sanctioned by the Law Society for advertising for a secretary so that people know where I was. And I was asked to explain why I advertised. But now we are all over with billboards, and not only, we don't have billboards in East Africa yet, but online there is a lot of advertising going on. And also we are doing through publications on our sites. So, and the competition is there. People get to know a law firm from what they see online. If you don't appear there, you can be sure the competition will be ahead of you. There are global law firms which are setting up in East Africa. We have a handful in Tanzania. The global audit firms establishing law firms. They're not yet here, but I know sometimes PwC wanted to set up one. And all the things are stretching the traditional boundaries of what we used to consider as the legal business. It's completely different. But if as an enterprise, this also has its own advantages because it gives us more an edge than we did have in the past. Now, I didn't want to really scare you about global incursion. You also have global reach. And for the young lawyers, I think you should really thank your luck in that we didn't have this kind of free advertisement on LinkedIn, on X, on WhatsApp, on Instagram, on Facebook. We didn't have that advantage at all, let alone the advantage Professor was talking about researching through Google and other apps. but you can actually also have this global reach out there, and the clients will come to you directly instead of going through a global law firm. And this we have seen happening also with us. So what's important is you have to be out there, online, visible through all these platforms. You cannot ignore them. And then Professor talked about investing in digital. One item, not only the telephone, but the laptop that brings you to the world. The world is only a click away. The laptop is your partner. You can work from anywhere, anytime. You store your storage of your clients' files and all information that you may need. It's your library. It's your source of information. It's your global connection. And this you have in your hands. So it's up to you to use those tools to thrive and to grow your practice, or to still remain analog if you want to, because some lawyers who are putting their head in the sand thinking this thing is going to going nowhere. It is not real. It's here. You have to focus on new products also if you want to grow. You have to innovate. If you are purely litigation practice, perfect your ADR and brand yourself as such. And for Tanzania, for example, it is now in the CPC that you will not go into trial before you do an ADR. And the better you do that, the more your clients will be satisfied, because disputes will be resolved faster at less cost. And clients are these days very concerned about cost. If you're a corporate commercial practice like us, you may look at the mergers and acquisition, see if that is where you want to focus. You may look at banking and finance, look how the banks are busy lending. You may look at how onboarding investors. You may focus on natural resources, if that is the sector that is flying, like in Tanzania for that matter. In tourism, you look at what sector you think is growing faster, and that is where you can go and invest your time and introduce new products to clients, which will make you more relevant and will be the differentiator. If you're a family lawyer, you can add insurance claims. You can add on about training, and that you can add in every practice that you have. If you're in white-collar crime law you practice, you can also add in training on issues like AMLA and AMLA compliance. Also, you can add up about data protection compliance. You can also train on you can also do investigations. You can get former investigative officers, police officers, other people, or those who want to come join you when they're still young, to do that job. It's an area that lawyers are not going, and I think those are the new areas that will be the differentiator to weather the competition. So how do you get those clients? We call it client hunting. I think you need to prepare a client hunting strategy that all practitioners ought to understand. You can share. You do branding and marketing with detailed action plan. Without that, you will not die, but you will not thrive. I can assure you that. Identify the key sectors, I've mentioned that, and the businesses and the clients to target. The key sectors are the sectors that are driving the economy. Those are the ones that you can look at. It doesn't mean that you cannot work in other sectors, but when you want to fly, the sectors that are driving the economy are the sectors that you should actually target. Target specific growing sectors, as I said, and the clients there, depending on your practice focus area. So if you're in banking and the banks are doing well, you should focus there. If you're natural resource and mining is doing well, I think that's an area you should focus. Look into sponsoring clients' events, or talk about a new product or updates on an existing product, which will be an outreach to clients. Also visit your client's business to understand them better and to cement relationships. You may also suggest to clients that you can provide, especially those who are very active, that you can provide an associate to be working with them. So the associate gets to know them and they get to have more confidence in you. That will help you thrive and not beat the competition, but be competitive. The targets for each, you must also have targets for each practitioner. Targets of revenue targets, so that you know the productivity of each of your practitioners. You must also plan how each can reach the targets and train your practitioners about targets. You should also make targets achievement and delivery as part of the assessment, practitioner assessment, and ground for promotion. What kind of tools that you can use for monitoring and evaluating your practitioners? You should have some methods of evaluation, which may be like the annual evaluation of your practitioners, the indicators which your practitioners must achieve, and how you measure that success and failure. All those things are very important, and the practitioners must know that they're being measured, they're being evaluated and monitored in that way. Recognize and reward exceptional performance. That you cannot avoid. If you don't recognize and reward performers, why would anyone bother to perform? That's very important. And that you should do on an annual basis. But also on a matter which is complicated and you have a practitioner who has exceptionally worked well, that practitioner should be rewarded. I mentioned about clear path to succession, which is important, so that the young practitioners, you can retain them. One of the things that we suffered over the years was losing practitioners that we thought they were not yet ready for partnership into the competition or they set up. And Rex became the university for practitioners until we woke up. So you need to also look for regional and global alliances, may be a measure, which is, I said, is a debatable whether there's more benefits for going out there, but also it gives you a leverage for the regional work that you wouldn't really have had if you didn't have that kind of alliances. And also look at other work which is related to practice, which may not be exactly legal work that can be done. And it's unlike during our days when a lawyer would be only do lawyer work, and sometimes it was only court work. Then the revenue. A lawyer who doesn't earn an income will be a very unhappy lawyer. At one time, I was attending training for billing by a US trainer, and he says, money does not bring happiness, but it takes you many places looking for happiness. So the revenue is the issue if you are, and that is the measure of you are thriving. So you must have an engagement letter before you start client's work. Once you receive your client's instructions, and once you understand the instructions, you must evaluate the nature of the work and propose a fee and agree on fees. Of course, there are regulations that are governing billing and invoicing for lawyers. And then there's also room for negotiating different levels and different rates of fees, including charging on the basis of hours expended. You must have a signed engagement letter before you start work. And that is also very important at the time of bill of costs. If you don't have an engagement letter, you have trouble proving your bills. And then when you invoice, you need to have a very detailed invoice. Just for legal work done is no longer acceptable to lawyers. They want to know what you did, and you must explain what you did. Otherwise, he will think you're taking advantage of him, and once that matter is closed, it will not come back to you. The invoice is another way of retaining, of client retention, because the client understands you and you understand them better. So how that invoice must be based on what you agreed in the engagement letter. Milestones for invoicing, for exactly, and critical must be stated. What triggers the first invoice for that matter, and what triggers the next? Even if it is billed on the basis of hours expended, there must be something that will trigger that invoice. And then, and the invoice must include taxes, all applicable taxes, plus bank details for payment, and whether it is paid in local currency or foreign currency. For those who are residents now in Tanzania, it will be 100% T shillings. And then invoice must show what, who, how, and the basis of what you did and the total. And of course, the invoice must carry what is called a tax, if it is VAT inclusive or exclusive, but the tax must be mentioned on the invoice. This is critical because without that, clients soon become aggressive. They may refuse to pay your fee, your invoice, and that is not good for a law firm. It drags you back into a battle with a client who you may lose. Better you understand in advance. And then there are issues that you really, as a law firm that is thriving, that you must statutory compliance. It's very important. And contributions, timely social security, workers' compensation, skills development levy, if you have it in your jurisdiction. And then your practitioners, of course, are top priority. Develop them, make sure you have policies that give them proper compensation. They have medical cover and life insurance and wellness as such. That makes especially the young practitioners who have families without medical cover, it becomes such a challenge for them. So make sure they are all enjoying medical insurance. And then, of course, invest in digitalization, data management, and branding tools. We already discussed that. Tax compliance, I already talked about tax compliance. If you don't pay your taxes, you are in trouble. You have to register with the Revenue Authority. Elsewhere, it will be Uganda Revenue Authority, and et cetera, et cetera. What would you take home from what I've been discussing? Legal practice is being disrupted faster than we know, from left and right. From global law firms are adopting AI with superhuman capability in research and analyzing of the law and commercial transactions. We were doing a transaction with a Chinese law firm. We share transaction documents that we poured on for several days, and within hours they return. And we even see the app that they're using, the AI app that they are using. And we also realize that without using AI apps ourselves in this kind of research and in this kind of world, we are going to find our fees are considered too high for the client. So we adopt the digital transformation or we perish, because the future is already here. You either keep up or you back up. It's not a question of choice, and this professor has emphasized so much. The competition now is no longer a cross-border practice. It is global, virtual law firms, audit firms setting up law firms, use of AI, practicing law about a transaction in East Africa from New York or Shanghai, anywhere, anytime. This is the reality of our business at the moment. So in East Africa, we must prepare now to face this future, which is already with us. And with that, I want to thank everyone for listening. Thank you very much. Over to you. Hello? Hello?
Thank you very much, Your Excellency. for that wonderful presentation.
Thank you.
What I get from your presentation is that law firms need to recognize and reward good work. Law firms need to have a client hunting strategy. Law firms need to be organized. And with recent technological developments, we have to up our game. Thank you very much, Your Excellency. I don't know whether our moderator has gone off, but in case she's not yet back, I would like to take the opportunity to introduce Professor Kariuki. Professor Kariuki is an advocate of the High Court of Kenya, a professor of law at the University of Nairobi, member of the Permanent Court of Arbitration. He has previously served as the Chartered Institute of Arbitrators, Regional Trustee for Africa from 2019 to 2022. He has on various occasions been appointed by leading arbitral institutions, including the Chartered Institute of Arbitrators, the Nairobi Center for International Arbitration, the International Chamber of Commerce, and the London Court of International Arbitration, among other institutions. Professor became the first winner of the inaugural CI Arbitration Kenya branch, ADR Lifetime Achievement Award 2021. He was also the winner of the ADR Practitioner of the Year Award 2021, given by the Nairobi LSK and the ADR Publisher of the Year 2021. He is rated by chambers and partners as one of the best dispute resolvers in Kenya. He has also published in the areas of ADR and access to justice, environment, and natural resources. Colleagues, join me in welcoming Professor Kariuki.
Thank you very much for that very generous introduction. I hope you can hear me, all of you.
Yes, we hear you, Professor.
Thank you. When I was invited by the organizers, I was quite happy to see that we are talking to mentees, at least most of them. And I'm a mentor, a natural one. And I quickly agreed to come and speak to them. Within about 5 minutes, I'd already replied and said, I will come and speak to them. But I'll not take long. I was asked to speak specifically on a topic called Passing the Torch, Mentorship and the Future of Law. Very exciting topic. What I am going to do, my slides are not as many as my colleagues, but I must say, I agree with what my two colleagues have spoken to you, and I adopt in full what they have said to you. I'll just add a few points towards the end. Immediately I was asked to make this presentation. I wrote a paper, and the paper is available online. It's a 16-page paper called Passing the Torch, Mentorship and the Future of Law, where I discuss in full sentences what I would have liked to say to you today. But I also have this PowerPoint presentation, which is only 4 slides, so bear with me as we go through it. In addition to that, I have made available to all of you, the 80 or so who are here, all my materials and books. I am a writer. I have over 20 books. The unique thing about it, yes, we can have the slides after the presentation. And you also have the paper, you have it already on your phone. And I have just given you 20 books available for free download. If you go to www.ecc.org kmco.co.ke. On my website, you'll find 20 books that cover sustainability. They cover ADR, and they cover law and development. You will also find publications in terms of papers, about 350 articles that are relevant for you. The reason I did this is because I discovered the average student in a public law school may not afford the books. So I had a discussion with my family, and I agreed that I shouldn't make money out of my books. I should instead donate them as a way of giving back to the society. So this afternoon, feel free to read my books, feel free to download, to copy, to do anything you might want, so long as you attribute them to one person called Professor Kariuki Muigwa. Just be kind enough to say he wrote them. So we are looking at passing the torch. So we the older generation, I'm 61 years old, are holding the torch. And how do we then hand it over to you? On a daily basis, I teach at a university. I also edit journals. And the knowledge that I have, I believe it's passed on to the whole world through social media, LinkedIn. There is also X. There is also Facebook. So we're able to reach the whole world in real time. And you'll find an article of mine every week without fail until further notice. So we are already holding that torch and passing it on to you, not by showing you how successful we are, but availing the very material that you will need. We are aware that there are very many changing dynamics, and you'll need to move with the times. So I begin by arguing that law and the legal profession has a very crucial role in society. It is a custodian of justice, human rights, and the rule of law. Lawyers are very important. They are agents of social engineering. You know, law is a tool of social engineering, and lawyers are right in the center of it. The legal profession is also integral in one of my pet topics, sustainable development. And the sustainable development goals are available, 17 of them. Online, you can get them. And the SDGs talk about very many things, including SDG 16, which seeks to promote the rule of law, ensure access to justice as well. And where I come from, the Kenyan Constitution has provisions relating to access to justice, Article 48, and many other articles that would guarantee access to justice for all. But there are emerging trends, new things that are coming up that are impacting the current practice and the future of the legal profession. So we say, and we believe that mentorship then is crucial in navigating those evolving dynamics and prepare the younger ones, the ones who are coming in right now, for the future of law, because it's changing. So what is the role of mentorship in the legal profession? Well, mentorship is key, and it's vital in building and nurturing legal professionals. Mentorship impacts and shapes the future of law by one, imparting knowledge and skills vital in the legal profession. And this afternoon, we've been talking about those skills one by one. I need not repeat them. Mentorship has also served as a platform for growth for young lawyers. And when I mean young, when I say young, I don't mean young in age. It's those who are coming in all over the world for many years. The mentor is able to show and enable the young professionals how to navigate the challenging dynamics in law, And through mentorship, young professionals are able to gain wisdom, particular wisdom related to that work, knowledge, very, very key knowledge, practical hands-on experience, and professional networks. I remember when I was doing my pupillage, we would meet very many lawyers over tea break, and they would be introduced by my pupil master, would be introduced, and you get to build a network, person by person, person by person. We still have a duty to do that. We need to continue doing that. So by fostering mentorship, then I argue that it is possible to shape the future of law with integrity, with competence, with commitment on justice, and fostering human rights. So mentorship and the future of law. There are emerging trends which have been discussed the whole of this afternoon. Just note what they are. And there is a need to keep up because these emerging trends are transforming the current practice.
Did we lose Professor? Yes, I think we can give Professor a short while to log back on. In the meantime, I have posted in the chat the paper that he just mentioned, Passing the Torch, Mentorship and the Future of Law. I also shared in the chat his a link to the books that he generously offered everyone. So as he comes back on, I want to encourage us to kindly please visit the Q&A section of this webinar and type your questions so that we can start to sieve through them. We will have very little time after our titans present. So it would be nice to get as many of the questions in already and already start to assign them to those who will handle them. Otherwise, I don't know if Professor is back.
We seem to have lost Professor. Perhaps we proceed to Senior Counsel while we wait for Professor to log back on.
Okay. As we wait for Professor to log back on, good afternoon to you, Senior Counsel Andrew Kasirye. You came in when we had already started and we haven't had an opportunity to hear from you.
Good afternoon. I've been sitting here listening in, and I thank you for inviting me, and I'm ready to proceed, as
All
is
right,
the case
so
when you go to court.
Okay. We can have Mr. Okot introduce you to our wonderful audience, and then you take it on from there. We had earlier agreed to allow each presenter 15 minutes, a maximum of 15 minutes, so that we can try and have some time left over for engaging with the audience. Over to you, Robert.
That's all right. Okay.
Thank you very much, Council Alinda. Colleagues, let's welcome Senior Counsel Andrew Kasirye. He is the managing partner of Kasirye Biaruhanga and Company Advocates. He is also one of the past presidents of the Uganda Law Society, and he is a senior legal practitioner in Uganda and the region. Thank you very much, and you're welcome, Senior Counsel Andrew Kasirye. Did we lose Senior Counsel?
He's frozen, but I see he's still on the call. Maybe we can just give it a little while. Gabriel, in the meantime, can you try to reach Professor to see if he's rejoining?
Yeah, sure. No worries. Let me do that. Senior Counsel is joining as well. He had dropped off. I see him joining. And here comes Prof. Okay, Prof is also back on.
Oh, there we go. Prof,
Sorry,
welcome back.
Sorry, I was thrown out. So before I am thrown out again, let me just finish. I don't know what happened, but we were reiterating the fact that there are emerging technologies. Blockchain, we've already spoken about that, artificial intelligence. And in future, you might even have AI judges emerging. And this is not a possibility that is so futuristic. In some countries, small claims are done automatically by machines. For example, traffic offenses, you are fined by a machine, and the machine determines your case. The other day I was speeding along a road. I did not know I was speeding, and I got an immediate reprimand on my phone that you are speeding, and they spoke to me about how life is important and so on. That could well be a judge, and that's where we are headed. We have areas like climate change, which are impacting how we practice the law. Climate change is real, and it's impacting the legal profession. So we find on the ground that there is a climate change litigation, something called climate justice, and lawyers are expected to come in and take up climate justice. And the whole area of sustainability, we call it ESG, environmental, social, and governance. And you'll find ESG clauses appearing in contracts that you shall take care of the environment, you shall take care of society, you shall take care of human rights. And you find them in arbitration clauses, World Bank conditions, and so on. So you are forced then to ask yourself, what is sustainability? Where do I come in as a lawyer? And ADR, or what is called alternative dispute resolution, is growing rapidly. And of course, we have this debate as to whether it's alternative at all in Africa, in the African context. One of the books I have given you today asks that very question, whether in the African context, alternative dispute resolution is alternative or is it appropriate? And in jurisdictions like mine, we have the Kenyan jurisdiction, you have the ADR policy, and then the TDRM policy. That is traditional justice systems policy, both working. At the international level, we have international arbitration at the New York Convention and so on. But we also have, emerging very quickly, the international mediation. And we have the Singapore Convention on Mediation, seeking to do what the New York Convention is doing for arbitration. So you'd have to catch up very, very, very quickly with international mediation, international arbitration, if you are a lawyer who is looking into the future, because futuristically, that is where we are going. Social justice, there's a lot of emphasis on that, and it's influencing the role of lawyers in policy making. So instead of waiting for a law to be enacted, you have a right through public participation to have a say in what laws come into force. You are an activist. You are going for social justice. You are not just a bystander. So you are then able to say, this is a law, not as a positivist, but as a naturalist. You are looking at the law as it ought to be, not as it is. And you are able to then argue that this law is not legitimate, or it's not just, or it's not fair. So we are then saying that mentorship is crucial in navigating those complex legal dynamics that are emerging, in preparing for the future of law, the future of legal practice. So in conclusion, we conclude that mentorship is a pertinent agenda in the legal profession, and it enables young professionals to successfully navigate emerging dynamics and prepare for the future of law. And in all those developments that we have discussed this afternoon, such as AI, climate change, sustainability, ADR, social justice, and so on, there is a heightened need for mentorship at all levels. I indicated earlier, we mentor people at the office level, at the university level, at the global level, sending out those messages and encouraging them to see the fact that they can move forward in this very globalized world. So I will then say that it is imperative to embrace and strengthen mentorship at all levels in order to fully prepare for the future of law. Thank you very much for listening.
Thank you so much, Professor. Thank you for your generosity. Amen. Indeed, you can't be a titan and not be a giver. We really, really appreciate.
Have we lost you, Madam Moderator?
Seems to be frozen.
Looks like we have lost you. But thank you very much.
Thank you very much, Professor. I just wanted to note that you were able to put a human face to the legal profession. As you rightly stated, that lawyers are agents of social change, but also you emphasized the need for mentorship such that the next generation and the next generation can continue benefiting from the legal profession. Our next speaker or presenter is Senior Counsel Andrew Kasirye. I don't know if he's back online. Gabriel, is Senior Counsel back?
Thank you, Rob. I do not see Senior Counsel on. Perhaps while we wait for him to join, we could take some Q&A from our participants and then proceed probably when he joins and sum it up.
Let me just get into the Q&A section. There is an anonymous attendee here who says that I'm a legal student at Cavendish University, Kampala, and a lover of the administration of justice and the rule of law. Do you have some specific legal advice and some legal books or research websites you can refer us to? As I'm still a student, I'm not totally allowed to help a friend on a legal matter in case where I can offer assistance. How do I go about it? I think that one could go to Professor Kariuki. Again, an anonymous attendee. Thank you for this great webinar. One of the issues that have been discussed has been mentorship. How does a mentee give value back to their mentor so that it is a win-win relationship?
All right. Could I attempt then?
Yeah, sure.
I have given you 20 books. I have given you hundreds of articles covering the areas we are discussing this afternoon. They are available. And in fact, in your social media, you will get them. And if you are looking for something, the first thing to do is not to walk to a library, you Google it. And you get original materials. For example, if you're looking for UN documents, original ones, you just Google that document and write PDF. You get a PDF of almost anything on this. 2016, we have tablets, smartphones that are so fast that you don't need to walk into that library. And then we have, if you're connected to a library, an institutional one, you have advantages because now you have things like LexisNexis, and so on. So it is possible to have all those materials. And it is okay to advise certain people out there, so long as you don't hold yourself out as an advocate. So is it possible? Yes, it is possible. How do you give back? I always tell my mentees, don't come back to me. Don't do anything for me. Look for another person to mentor. And let's pass it on. Let's not be mean to each other. Let's mentor this. If I had not been mentored by people who saw something in me, I would not be where I am. So at least mentor somebody else and move forward. Are you going to make it? You see, you become exactly what you think you will become. What you talk about in your mind is what ultimately you will become. So I would encourage you to dream very big, so big that your friends get scared. You see, don't fear success and don't fear failure. And the fear of success is so great, sometimes it overshadows the fear of failure. I wish you the best. We are available. If you go to my website, you'll get a way of communicating to me immediately. Thank you.
Thank you very much, Professor. And you're welcome back, Madam Moderator.
Thank you, Robert. I think that with the technological challenges, it is decided to have one moderator. Thank you so much for keeping the front. I had a question for Mr. Resida. One of our attendees, Mr. Wangondu, says, how can law schools curriculum align themselves with the futuristic practice of law? And as you answer that, Mr. Resida, specifically, I would like you to speak to us about the shift in the focus and skills from the courtroom lawyer, that was the traditional focus of all our training and of all our educational curriculums, or through the legal education systems, to the multi-sectoral approach that legal advisory and transactional services now require of us. Over to you, Mr. Resida.
Thank you. Thank you to the person who asked the question, and thank you, Linda, for this question. I'll try and run through quickly an answer that I think will guide all of us in the understanding that big change. First of all, in terms of training, in terms of how do you teach someone, let's see understand Africa is largely focused on training for court. And we get into practice, and there's more work than what we're largely biased for. And so one of the things is a mindset change that takes us away from that thinking of being a lawyer for court and focusing on litigation, evidence-based presentations, substantive procedural law, precedent-based, and so on, where the art of advocacy really plays a key role with persuasive communication. Now, how do you shift to what you are not training for? And legal advisor services, in-house lawyer, consultant, the analytical problem-solving aspects of a lawyer, how you communicate with the clients, how you do research in that space of problem solving, how do you form contracts, how do you review contracts. No one ever trained me on how to do a mergers and acquisition transaction, but I've done a few, and I can assure you they are not a small piece of cake. I led, as a lead negotiator, I led negotiations for a client in a foreign country with a Marriott group of hotels. Those hotels, the chains, typically you are negotiating multiple agreements. There's a management agreement, technical services agreement, key money agreement. Then there is a fire and safety aspects of it. There's a technical services. So you are negotiating 6 different agreements for one project with different people, different backgrounds, different professions. Technical assistance simply goes into the architects who come to advise the project owner, but Marriott insists on their standards, so they want their architects to come and interact with your architects, with your structural engineers, with your contractors on how to build a Marriott hotel to their standards. And you are in there listening to different disciplines. And at the end of the day, it is you to put all this together into one document that is called an agreement. So we are not trained for that. Now, the beauty with today is the flexible training options that are available, and that we should really be availing to ourselves and make sure that we don't pass that opportunity. So how do you do this? You've got to understand that the uptake on the technological advancements, the legal tech, the data rooms that are used in transactions, the reporting formats that come with all that, all those skills that are necessary to navigate complex transactions, different business environments. Professor talked about ESG. ESG is a whole concept on itself. It's no longer just a clause in agreements. It's beyond a clause. How do you do this? So, personal initiative, continuous legal education, ensuring that you are on top of the curve in updating yourself, in ensuring that you move with the times is very, very critical. Again, as Professor said, online sources, and I did highlight this in legal education, they're there. They're there. And in my opening remarks, I said this afternoon I'll be learning. I have learned a lot. I've listened to the ambassador, I've listened to Professor, I'm listening to the questions now. That's how we learn. Now, so there's a formal education, there's the informal education. How do you match the two? How do you inform yourself? How do you move on? How do you learn that it is important to understand a client's business if you are going to risk every day? You run a risk of being looked at as a cost center because you're not a revenue center to a client. They have to pay you, they have to engage you, and your value is in what you do in court. In businesses, the transactions, and the advisory services, and the consultants, that's different. What value do you bring? Are you simply a cost center or not? So those challenges live with us. It's something that we really have to keep updating ourselves on. And so the answer is, let's embrace continuous education. Let's embrace technology. Let's embrace and learning a few things and running others. There are more slides in that when, if there's time, we can engage in that. But that question, that's how you would approach it.
Thank you very much, Council Alex Resida, for those wonderful comments. I will have some questions to Her Excellency Ambassador Mwanaidi. And the first question is on the aspect of cross-border practice and its reality. Your Excellency, at least you come from the background of being a diplomat, and at least we know that our treaty has been trying to see that we have free movement of labor within the region. But again, we still have challenges of protectionist tendencies within the membership, because other than Kenya, the rest of the member countries within the community, it's hard for someone from another country to practice in that country. We've just seen how lawyers from Kenya have been struggling to get licensed in Kampala, to practice in Kampala. So is this cross-border practice something that can be really be achieved? And then number two, again, the legal profession thrives when you have thriving economies. But as we can see, our economies seem to be growing at a rate that is not favoring the rate at which lawyers are being graduated from law schools. How do we navigate such situations? Thank you.
Thank you, Council. On the cross-border business, for many years I've been hearing about it being easier for non-Kenyans from East Africa practicing in Kenya, but I don't know, maybe you will tell me how many non-Kenyans are practicing law in Kenya. I know in Tanzania we have Ugandans and Kenyans practicing law, and I know our legal system allows a non-Tanzanian, as long as they partner with the Tanzanian, to set up practice. But this has not happened. So, and myself at the moment, I don't even consider the cross-border practice an issue anymore. Because now, if you have the right contacts or you have a client in Kenya, you can actually be the lead lawyer. And if you're not interested in partnering with the Kenyan, and you are sure that you can do the business without Kenyan, you can proceed. As I said in my presentation, practicing law anywhere, anytime, is the norm at the moment. Lawyers from another jurisdiction practice, especially on transactional matters. The issues that would restrict is when it comes to the other matters, especially those which are litigious, or those matters which relate to, say, family law and criminal law for that matter. So for me, cross-border and free movement of labor, it's something that I think in East Africa will do us good if we introduce it, but every member country is dragging their feet. And those that are opening may have assessed their situation and they think they're better off doing that. But for me, cross-border, I cannot overemphasize the fact that it's not really the issue. It's the issue is the global reach that you may have as a local firm, or as a partnership or joint venture with foreign law firms. So I don't know what to say to that. And I said it's debatable. But for many years, this has been the issue that we've been discussing. And I don't see where we have gone even further beyond anything else. I haven't seen regional partnerships. Or for example, you have law firms, global law firms, partnering with the local law firms and establishing in Kenya. I haven't seen one Kenyan law firm that came to Tanzania and looked for partnership and working together. It would be it wouldn't be turned out for sure. So the issue is how you want to set up. If you want to come alone to practice law in Tanzania, you will have issues. For registration, foreigners cannot register a business. They must have a national ID and the other things that will follow there. But I know Kenyans who are practicing law in Tanzania. In fact, I know Ugandan who has his own law firm here. So it depends the point of entry. And I said we have seen global partnerships, but we have not seen regional partnership. This is for sure in East Africa. I haven't seen any. That's number one. Number two, you are talking about legal profession thriving when the economy is also thriving. That's true for commercial practitioners. But you may have a situation where the economy is not thriving, but a situation where there is so much heavy hand of government on businesses and people that the cases that you get are more criminal cases or cases of compliance or non-compliance, where government agencies become now like they are trading business. So it depends what area you are practicing. The corporate commercial, it depends a lot on how the business is growing and how it's performing, how the economy is performing and how it's growing. That's all I can say. Thank you.
Thank you very much, Your Excellency. Go ahead, Robert.
No, I was just thanking Her Excellency for that response. Please go ahead.
Excuse me, I'm a practitioner, really. Excellency isn't relevant here.
Okay, thank you. Thank you for giving us that permission. I'm an advocate. I see Mr. Rezida's hand up. Would you like to chip in on that question?
Thank you, Linda, and thank you for that elaboration on cross-border and the partnering that are not happening. But the emphasis is good about the ability to practice without crossing borders. But my hand was up for something slightly different. Robert, you are right and on that question which has just been answered. You talked about the rate of graduations from our law schools. And this is important. We tend to not to focus on certain realities. You see, legal practice, the thriving of lawyers, building everything we've talked about this afternoon, has a correlation to the economies of these countries. How many lawyers can Uganda's economy absorb in legal practice if you look at the number of graduates coming out of law schools? And yet we are still training them court. What are they going to do in the courts? How many can an economy absorb? And this calls for that shift away from this thinking that as a lawyer, I must draft a plaint and urge a notice of motion application before a judge and so on. Fair enough, you're there in court, but how many of us can an economy absorb? And so, should we look broader? How are we skilled touring ourselves? How are we looking at problem-solving education? How are we emphasizing the clinical aspects of legal education that will give us the tools not to just look at court, but to be relevant in every other sector, be it insurance, be it banking, be it construction, be it. And as lawyers, you always remember that when you have a base, as a lawyer, as your starting point, growing in other areas, it is so easy. It's so easy. You rise faster. Even if you go into legal advisories, even if you develop you join the accounting firms, but your best degree is law, you tend to rise faster. So that shift in attitude, that shift in outlook, that shift in appreciation of the enormous potential of a lawyer is something that we really need to work on. And again, in terms of education, even our teachers, our lecturers, those responsible for our curricula need to start refocusing on the future lawyer. Thank you.
You are really, really spot on. I always get the sense that every other profession has seen how they can penetrate our legal profession, but we still remain so full of the legal profession that we refuse to also go and permeate others. I think that it's high time we realize that we can create value in those other spaces as well. And yes, like you said, it really requires a mind shift and a serious change in how we perceive our contribution to society. We are now 2 hours into this webinar, and we committed that it would last 2 hours. I think we have answered all the questions that were in the chat and in the Q&A section of this webinar. I see that Mr. Senior Counsel Andrew Kasiri has managed to come back on, and maybe in a few minutes, as we start to wind things up, we can just hear what he had prepared for us, and then we can take a round of closing remarks from the rest of our panelists.
Yeah, thank you, Linda. The technology played me, it went off, but it has come back on. Basically, I was going to talk about the challenges I have had, which really come from a bar bench relationship perspective and some aspects of the bar. I wanted to provide context that I was admitted to the bar in 1986, 16th of April. And so I wanted to talk about specific areas. One was judicial etiquette, and then number 2 was the current crop of judges. The next bullet I wanted to raise was new local judges. And I wanted to conclude with the quality of the bar. And basically what I wanted to mention is that in the so many years I've had, there has been a challenge in judicial etiquette. The judges you meet are not robots. They are not the same. When I started practicing in 1986, they were trying to build the highest bench. There were expatriate judges. There was a Justice Seaton. He came from the Caribbean. He had been a former Chief Justice of the Caribbean. There was Justice Harold Platt from Kenya. And alongside them were our local senior justices, Wambuzi, Justices Odoki, Justices Arthur O'Dare. My challenge in his experience there was that all of these justices needed to be approached differently. And you would have to know what the judge is inclined to do. Some were very patient listeners, some would interrupt a lot, some would give you leading questions to guide you, some were just combative. I remember in the subsequent years when Justice Kanye Hamba joined the Supreme Court bench, he brought a lot of combat in that area. Another comment I had wanted to make was regarding the High Court bench in Uganda. They also had an influx of expatriate judges. We had a Justice Berko, I think he was a Nigerian. There was another Nigerian British judge, and there was a Justice Raja Singham QC. Now, their approach, especially I remember in the area of interlocutory applications, was very different. These British judges did not want lawyers to come out and argue. They would just say, I have seen the affidavit. Is there anything more to add? And they would not let you argue. And they'd give you a date to come back for the ruling. And this became very controversial. Of course, we had been raised differently. We were arguing applications for injunctions, stay of execution. But the British judges and the expatriate judges who came under that Commonwealth Fund had a completely different etiquette in this area. And so that would be a challenge. So depending on who you are going to appear before, you needed to know how their approach to your participation would be. Of course, today at the highest bench, there is harmony of approach because we have 100% a local crop of justices, and it's much easier to manipulate and navigate at that level. But an observation I was also going to make is that when new judges were appointed under the old dispensation, there was no judicial college. And my experience and the challenges there was that the career judicial officers, who do I mention? Those from Uganda would know Justices Karokora, the late, Justice Okalebo, I think the late, Lady Justice Kikonyogo, the late also, Lady Justice Biamugisha. They were magistrates. They came up from the lower bench and became High Court judges and went up to the appellate courts. They adapted quicker and their approach was more predictable and manageable because they were career judicial officers, as opposed to the others who joined the bench, like from the bar or from the government bar. Justice Julius Sebutinde, my good friend, Justice Musoke Chibuka, Justice Moses Kalanda, and so on and so forth. These judges were not subjected to any training, and it was basically throwing them on the deep end. They were judges, and they had to swim their way from the deep end to the shallow end and dispense justice. That was a real dilemma. No orientation, adaptation, or onboarding in the formal way that the current judges have. Currently, we have a cocktail of lawyers joining the High Court bench, and my observation here is that there are so many half-baked lawyers, with due respect, who took on judicial office because of the attractive new emolument package. And speaking from where I see things on a balancing scale, the percentage of persons who should not be judges in the first place, they outweigh those whose competence speaks for themselves. I will not name names, but practitioners here know what I'm talking about. There are too many new judges who do not even exhibit a knowledge of the law or procedure, and this is going to affect the jurisprudence coming out at the level of the High Court and burden the First Appellate Court with unnecessary appeals. I wanted to touch a bit on technology, and my observation there is that I do go to India frequently. I have some clients who just take me there for a medical review, but I always go to the courts and see what they do there. So in that respect, I picked up a few books about IT and the law and their judicial system, how they adopted IT. And I have shared those with my good friend, the Honorable Mr. Justice Geoffrey Kiriabuide, who is a key player in the adoption of technology in the Ugandan judicial system. My comment here is that the ECMIS, the Electronic Court Management Information System, was poorly implemented by the judiciary. I think they were not prepared. They never had the resources or the infrastructure to roll it out. And there was inadequate training for both the bar and the bench. But I dare say that they have currently all adopted. We seem to have found a level in the electronic and digital court systems, and I think they are performing much better now. I commend the registrars who have helped to ensure that the transition from analog to digital courts succeeds. And I made an observation. There is a very active civil servant called Pius Bigirimana, who is the Secretary of the Judiciary, who deserves recognition and commendation for his proactive efforts to ensure that the judiciary budget captures the required innovations in the administration of justice. Finally, I'm talking about the quality of the bar. I really appreciated Her Excellency Ambassador Manaidi's comments about lawyers and law firms and what they do in their law firm. I've had a law firm for about 3 decades or so. This is the poorest crop of lawyers in the marketplace today, and it's not their fault. The education system has declined, the legal training system has declined, and I think the applicants and the new recruits are motivated differently. We never came into a legal profession to become rich men. The wealth came as a result of being in practice. But that's not what took us to study law. Unfortunately, many of our young recruits just came in for the money, motivated by money and future material gain, as a result of which we have a floodgate of poor candidates and never overburdened the postgraduate bar training system. My recommendation here is that this blanket gateway to the legal profession needs to be closed or constricted for a while, and we need to recalibrate the younger recruits and try through the continuing legal education to panel beat them into the right quality of advocate. Linda, I rest my presentation. Thanks for your indulgence. I came in late. My fellow panelists, I apologize. My technology let me down, but I thank you all for your presentations, right down from Alex, the professor, Your Excellency. I was happy to see you again from afar, and I hope that in future we will interact at these conferences. Thank you very much, Linda.
Thank you so much. Thank you so much, Senior Counsel Andrew Kasirye. We really needed that
I will upload and separate my bullet points. They're easy to follow.
And the more and it's comforting to hear that a lot has come to an end. We're almost 30 minutes past our closing time. So I just request each of our titans to take a minute each or under a minute to just give us your parting shots so that we can release our wonderful audience. We'll start with you, Professor, and then we will go on to Mr. Rezida, then we'll come to you, Ambassador, and finally, Andrew, you'll have the final word.
Thank you very much. I have enjoyed myself. To the people who are listening, the mentees, what worked yesterday will not necessarily work tomorrow. It's a very competitive world. AI is here to stay. IT is here to stay. But there is hope. There are new practice areas that you must go into. areas that are really not taught in schools. Article 33 of the UN Charter is to the effect that if there's a dispute, you shall deal with it through negotiation, mediation, conciliation, arbitration, and other methods. I think that is an area we should go into. If you go into such an area, you deal with the problem of cross-border, because some of us who are in that area are able to practice in more than 150 countries without a problem. Globalization is here. Second thing I will say is that it's something I picked from one of the panelists, that you must know the business of the client. You must know the business of the client. I think personally that this business of calling ourselves learned is completely misplaced. If you are in aviation, you must learn aviation. If you are in something like water resources, you must learn. Africa has now the green minerals. What are they? The periodic table must be learned. So there is a lot to learn, and there is hope. And as we pass the torch, there is brightness in the future. Thank you.
Positive note. What a positive note for you to send us all. All right, Mr. Resida.
Thank you again, Linda. My parting shots really just two. One is to thank everyone. Two, to emphasize the aspect of the human touch in this AI era. Let's not despair too much. The human touch is still around for a while. But what is your human touch in the context of technology today? Please don't be left behind. Do not, again, as I kept saying, it's not budget neutral, there are expenses, there are costs involved, but nothing comes easy. Invest. If you don't invest, there are no rewards, no returns. You will get left out. Again, Ekimis showed us many things. Then Senior Counsel Kasiria and Andrew, thank you so much for the presentation. Yeah, you touched something about changes in the evolution in the judiciary and so on. You paid tribute to the Secretary to Judiciary, Mr. Bigirimana. I also want to do the same thing, but for a specific reason this time. He has really pushed hard both in budget and innovations and supporting the development of IT and so on. And so one of the things we are going to have in this new financial year, come 1st July, is a performance measuring tool for the judiciary. There's a tool which has been adopted, developed, tested, and they are going to roll it out in this coming financial year. So we have performance evaluation finally in a more formal way for our judiciary coming. Not only performance in broad terms, but it will be detailed. It will tell us when you say disposal of cases as a judge, what disposal are you talking about? Is it a dismissal because parties didn't come, or is it a disposal because it was hard on merits? Was it an application? Was it judicial review? Was it a full hearing? What was it? So that we're able to see the output, we're able to see what is going on. And that's a great advancement for us practitioners here. It's something we've really been looking forward to, and we are glad that finally there's something coming. Thank you so much.
Thank you. Thank you so much, Mr. Resida. Now we come back to you, Ambassador, for your closing shots.
Okay, Asante. Thank you. What I can say to those, number one, I must first thank you very much for inviting me. It's something I can say I appreciate a lot. And two, I would like to tell the young people listening to me today that today it's not only about the law, and you've heard this from my colleagues also. It's about new products that are coming from law offices. And these new products are all over. I mentioned some, but there are things that you can do different from what you do. It's not only about dispute resolution. And if it's dispute resolution, it's not only about judicial process. It can be through arbitration, mediation, adjudication, and these things are now provided for in the law, but also most of the transaction contracts now require a mediation or arbitration without first going to court. And then, of course, the new things that are coming out which have legal implications. He's mentioned ESG and climate change and others which are coming now that you need to study them and understand. You cannot just assume you're going to be working only in the areas that you learned in school. No one teaches you everything in school, in school or in the law school. And then AI will not replace us, at least not in our foreseeable future. And I've seen, and I've used some of the AI, sometimes it creates their own content. So you really have to be very careful when you're using them and not trust them 100%. But the apps can actually make your work easier and faster than you can ever imagine. But you've got to actually also know the issues that are being raised and cross-check whatever research results you find. When I was researching on this topic, I came across a matter that happened in South Africa. I got court decisions which never existed. So the machine must have created that court decision to please you. And I think that can be very costly for lawyers. It's something that you must avoid. But that shows that these machines cannot replace us, but they will make our work much more easier than it has been. Just like the invention of the typewriter. So these are the things that I'm saying will help us. And then you will recall those days for those who are my age, where you even typesetting and correcting a document, you have to do that manually. And the changes that have happened with digital. So it's making our lives very easier as lawyers. The last thing, hard work can never replace anything. You have to work hard. You've been given 20 books. I suggest you read them because professor thinks and knows that these books are useful. And you can download them for free. You don't get free books so easily. But what I can say is wean yourself from your devices. Reading sites which are not useful to you. What Trump is saying, what he's doing, that's none of your business at the moment. You can read quickly to get to understand what is happening in the world, but pay attention to your professional development rather than these sites which excite you, but they don't actually develop your career. I wish you all the very best and feel free to get back to us. As Professor said, we are mentors and we love mentoring people. And we don't expect a return, but your success. Thank you.
Yes, you don't expect any return except our success. And that resonates with what Professor said, that all of us is to pay it forward. So your last passing shots, Senior Counsel Andrew Kasirye, and then we'll call this a wonderful webinar.
Thank you, Linda. I associate myself, of course, with Professor's views and Alex and Her Excellency Ambassador Mwanaidi. I just simply wanted to add that I have been disturbed by the bulk of our practitioners are Gen Zs, and they look at those of the seniors who try to play an advisory role or a mentoring role. They look at them as dinosaurs or relics of the bygone past. But like Professor and Ambassador have emphasized, we have a role to play to mentor. It is our duty to uphold the quality of the legal profession and to develop the younger generation. IT is not everything. Digital has come, but so did typewriters and fax machines and telexes and faxes went. The technology will keep on changing, but there are certain constant parameters in the profession that needs to be maintained and developed, and to maintain the honor and dignity of the legal profession. So I thank you for the opportunity. I thank EALS, and let us not stop having these sessions where the seniors come and share. We are not patronizing, dear colleagues. We are just sharing experience from which you ought to benefit. And even if you do not, you could find something to pass on to other people. Thank you very much, Linda.
Thank you very much to our esteemed panelists. This has really been a very wonderful conversation. And thank you to the East Africa Law Society for having made this happen. At this juncture, I would like to invite Gabriel to do us the honors.
All right. Thank you, Robert, and thank you, Linda, for that extraordinary moderation and for keeping this quite lovely. Ladies and gentlemen, as we conclude this very inspiring session on behalf of the East Africa Law Society, I would like to express our heartfelt gratitude to everyone that has made this webinar a very remarkable event. To you, Senior Counsel, Her Excellency Mwanaidi Mwaja,
Rogers,
Senior Counsel Andrew Kasirie, Kariuki Megua, thank you so much for illuminating storm from the historical sweep of cloud and looking forward to the torch. Your reflections have not only been one of resilience, but one of innovation and mentorship. And I believe that has enriched us, the younger generation, even more. You have reminded us of very important lessons that while the legal landscape has continued to evolve, our commitment to justice and integrity endures. To you, our vibrant audience, colleagues, ladies and gentlemen across East Africa and beyond, thank you for your continued participation. I pray that we take the lessons that we have learned from our seniors and honor their legacy by embracing tools today and paving a path for tomorrow. I thank you so much, our seniors. A recording of this session will be shared on the different email platforms along with the presentations. Thank you, thank you, thank you. We cannot thank you enough, and we look forward to hosting you at our capacity building sessions. And with that, ladies and gentlemen, we wish you a very lovely afternoon. And this Thursday, we'll be discussing business and human rights. And so you want to listen in for that particular session. But from now, I would like to wish you all a very lovely Tuesday evening. Stay blessed until we meet again. Goodbye.